Second, Judge, the state's argument about essentially alleging that the defense photos were made up after the fact was completely done in bad faith. The photographs of Mr. Baptista that they took were presented and discussed to the grand jury that was discussing his case 4 years ago. They've known about those photos for 4 years. The grand jury was shown them, they were asked questions about them, and now for the state to get up and not suggest, argue that those photographs were developed or fabricated after the fact when they knew they were presented to the grand jury is completely inappropriate. And so we are asking for a curative instruction that tells the jury that these photographs were known to the state 4 years ago when they were presented to the grand jury.
Judge, they were not known to the state. They were not presented to grand jury. That was the whole reason we have the case trial for Demetrius Elder's motion for new trial, because those photographs were provided to the state on July 31st of this year.
Judge, I think we need to, then I would move to unseal the grand jury minutes, Judge, to unseal the grand jury testimony, and the transcripts. They're going to be in there. I mean, Mr. Baptista testified at the grand jury, was asked questions about those photographs. They're there. Ms. Alcalde, the prior assistant state attorney, was there.
Take care of it. Let her handle it. Yep, whatever she wants to do. I'm sorry, Joe. Go ahead. Go ahead.
So, Judge, I'm moving to unseal those grand jury minutes. I would, and the transcript itself. I would have no problem in asking Mr. Baptista. We can put that on the record right now that he testified that those pictures were presented, that he was asked questions by the grand jurors themselves about those photographs. And now for the state to come up 4 years later and say that they're fabricated is a completely misleading of this jury.
Ms. Alcalde didn't recognize those photos. She was asked about them. She said she had, Ms. Alcalde, the ASA who went to grand jury, said she didn't recognize those photos. She didn't have them. She looked through the entire file. Everything that she had that was presented to grand jury was in the file. She looked at it.
That was here.
Yes. Those photos that were provided on July of this year by the defense were not in there.
Well, there's a very easy way to find this out, Judge, and that is to unseal the grand jury evidence.
I don't think that there's a proper motion that you can base unsealing grand jury testimony. You're taking the testimony of a person who was not at grand jury and versus the proffer of someone who was in grand jury. We can bring Ms. Alcalde in. She's the only person in this room other than Mr. Baptista that was in the grand jury. And so I believe the proper way to doing it is to first inquire in camera of the people that were in the grand jury whether or not these pictures were presented. And then if there's an issue that the court finds, then it may be proper upon motion to unseal the minutes. But just to do it based on a person's argument who wasn't at the grand jury is improper.
Mr. Baptista was at the grand jury.
Right, so you're giving a proper.
I mean, I would have no problem if the court is going to consider the motion. I would have no problem putting him under oath and having him answer questions to that.
And I would still maintain that would have to be done in camera,
Of course.
as the grand jury minutes are still until the court deems proper to unseal them, and there has to be a proper motion, not an or tennis motion.
Well, what we have is the state saying that they made, I want to get the issue clear in my head. The state argued that those photographs that were introduced by the defendant were just done this year, in essence.
No, not at all.
No.
I've never put that time or date. I said they were fabricated at a later date, not April 25th or 26th of 2014.
Okay. obviously they were taken after April 25th or 26th, right?
Correct. They were taken after the incident.
So, what? I mean, what?
Well, that's
So she didn't say that they were taken this year. So why would I have to unseal? The grand jury was when?
July of 23rd of 2014.
Okay. So she didn't say they were done after the grand jury.
During her questioning, she specifically said, "Doesn't he look pale now?" Referring to Mr. Baptista now as looking pale. And now she's saying, "Oh, he's pale in these photographs." So he must have fabricated these photographs recently.
That's not what she said. She never said recently.
She very specifically referred to Mr. Baptista as being pale now. He looks pale like he looks now. That's what was the questioning was done.
Never said recently, Judge.
I'm going to deny the motion based on that. I don't see any reason to go into the grand jury. Had the state indicated that that was taken at any particular time after the grand jury had convened, then I would agree with the defense, but that's not what was said, so I'm going to deny the motion.
Yes, Judge.
Now, do you want to write the curative on the other one?
Yes, Judge. And do we have is there, I'm trying to figure out a way to zoom in and zoom out. Do you guys have a remote or something?
Yeah, you were doing something with this.
I know, and I told him that it works on a remote, and when Miss Bradley got back, I was gonna ask her if she had the remote, because I told her it's not there.
It's over there next to the rest of the evidence.
It's right here.
Remote's over here.
It's right here on the little table. Joe, do you?
You want to try it out before you?
Thank you, Judge. Thank you, State.
You got it. It's working for you.
I'm going to draft the curative instruction. It is working. Thank you, Judge.
Then please show it to the state. Yeah, yeah.
Sorry.
You're done ripping now, so we can continue with the trial.
Is that the full statement, or is that,
No.
what is it?
510 to 808. 803.
And what part is that in the transcript?
Show you just a second.
Elaine, when you're taking back the evidence that is going to go back, not all of it's going back, obviously. The verdict form's right there to go back with it. They do not have the verdict form back.
It's the other page. This is the page that I had.
Okay. so
That's why
you got a
I gave it
verdict
to you,
form.
because I didn't want to spin it around anyway.
So I just want to make sure you want them. You changed from 30 to 10, correct? I'm sorry.
Yeah.
I'm sorry. No, go ahead. We'll talk about it later. It's like saying verbiage, which is not correct. It's verbiage. Okay, the court reminds you that what the attorney says is not evidence. There's been no evidence presented of any blood spatter on the outside of the door, outside of the car. And I assume you're objecting to that.
Yes, Judge. What the only curative instruction that would be proper would be to say that what the attorneys say is not evidence. Jurors are to rely on their own recollection of the testimony and evidence. And just because spatter is a term that could be in the area of an expert does not mean that, and there was testimony about transfer, and that transfer is something that is touching one surface than another, that to describe this as something that is sprayed on the outside of the car versus spattered on the outside of the car is the same thing. And that's the same argument that I'm making there. So in terms of whether there was or was not evidence, there is evidence. There's photos of the pattern of the blood on the outside of the
You
car.
want to add to this that spatter is a term that may or may not require expert testimony, or words to that effect?
No, Judge, I think you're just compounding the error of that.
Okay, I'm just asking. Okay, I'm going to give it as written over the state's objection, and I'll give it, wait, I'm looking at this again.
Where are you on the transfer for the idle units in the car?
I am a little confused that this is, I am concerned this might be a little confusing as written. There's been no evidence presented of any blood spatter. I think we need something more in there on the issue of spatter, because they might, I mean, I don't.
Judge, I mean, this is like you correctly said, I think the only curative instruction you should give is the first part. He's free to argue in his closing that there's no expert testimony on the pattern of the blood that was outside of the vehicle. He's free to argue that. But for the court to instruct the jury that there's no evidence of that, of something that they can deduce on their own, they can look at the pattern and see that it's splattered.
That's where my concern comes in.
Judge, they cannot do that. That is evidence requiring of expert testimony, specifically with regards to spatter. They can't look at the blood and decide on their own what that blood constitutes.
And I disagree with that, Judge, because you're also instructing them that they can use their common sense. And if you've ever painted before, it's the same thing.
I'm not concerned about that. My concern is the fact that blood spatter evidence does require expert testimony. Using that, you're saying no.
No, not at all. We're not saying that this is being dripped off off of a weapon, off of a knife. We're not trying to do anything with causation as to that, Judge. We're saying that there is blood that is spattered on the outside of the car, and you can see that from the pictures. You can see also the difference between the spattered blood that's on the outside of the car and the transferred blood that's on the inside of the car. For example, the palm print on the inside of the column.
But see, I don't want the jury to think there was no evidence of blood on the outside of the car, because there's no dispute about that. And if we did a curative instruction that, I'm just, again, while there's evidence that there was blood on the outside of the vehicle, there's no evidence that that blood was spattered.
Judge,
I have no problem with that.
Judge, the problem is that the court is now doing what the defense attorney is supposed to do. That's his job to comment on what evidence was presented and what's not presented. He's going to make in his argument that the state said that there was blood splatter on the outside of the vehicle. Did you hear any expert come in here and say that this blood was spattered? That's his job. It's not the court's job to tell this jury whether or not the blood drops on the outside of the vehicle was or was not splattered, and whether or not they should not consider it.
I disagree. The state is not permitted to introduce facts in her closing that were not in evidence. This is curing that error made by the state. That's the entire purpose of a curative instruction. I am not supposed to be getting up here and saying what she told you wasn't true. There was no that the evidence that she said was there wasn't there. She's not permitted to do that in the first place, and it is the court's function to cure that error that the state has made.
Well, here is what I'm going to give, and obviously it's over the state's objection. I'm going to say, while there is evidence, I'm going to read, the court reminds you that what the attorneys say is not evidence. And while there has been evidence of blood on the exterior of the car, I am just worried about how the jury is going to take this instruction. I obviously sustain the objection. Therefore, since I sustain the objection, defense has a right to ask for curative instruction.
It also has to be timely, Judge. So now this is coming totally out of the blue.
Oh,
I made a timely objection.
yeah, and did I offer this defense at the time to do a curative instruction? I don't remember. Because if I didn't, then that's on me. And I have,
Well, just so you're saying for every single objection that's made, you have to give a curative?
when I sustain an objection on closing, and I'm supposed to ask if they wish to have a curative instruction. If they say no, it's no. If they say yes, then I ask them to write it up. And what you're telling me is I did not ask you that at the time, correct?
Correct.
All right. Because if I asked them that at the time, all right, here's what I'm going to give. The court reminds you that what the attorneys say is not evidence. While there is evidence that blood was on the outside of the car, there was no evidence as to the manner in which it came to be on the outside of the car. Okay. Before we go now, before we bring in just scheduling issue,
Judge, if that's the curative instruction, then I don't want it.
Okay.
I specifically want an instruction to say that there was no evidence of any spatter on the outside of the car.
okay, then I won't give it. All right.
So it'll be over our objection,
Correct.
not giving something, fixing the state's error and saying there was spatter on the outside of the car.
Okay, now, this document, we have to put this in, correct? Because I crossed out something and I've written something on it. Okay. Now, quick scheduling issue. It's 25 after 11. You've got, your 90 minutes. I guess we'd have to break for lunch then when you're done.
No, we can keep going.
Keep going, then because they don't have to read jury instructions after that. So then they can go right into deliberation.
Well, if he goes 90 minutes, that's 1 o'clock and you got a half hour.
Yes, Judge, I don't think I'll take that much. So.
All right, then, let's bring it back.
Judge, there was one issue Ms. Johnson caught in the verdict form. It said charge in the information. It actually is recharged in the indictment. Yes, so that's the updated. I already gave a copy to defense.
All right, let me get rid of this. Elaine, get rid of whatever you have.
I gave it to you.
Okay, so you don't have any of these, right? Okay, this is the one that's going to go. Okay, this one can go here. Okay, go get it.